Hey folks, I was looking at a couple of the postings on the Father's Rights page today, and I've been divorced. Well, I've been dealing with a divorce from 2006 for, basically, there'll be 13 years in July. Um, and I think that a lot of times there's a lot of questions on how, as a non-custodial parent, you can react to certain things. And the general mindset, I believe, is that people, well, the custodial parent has all the rights, and I'm just stuck. I'm going to be stuck for 18 years of dealing with craziness, and they're going to be able to do whatever they want, and I just have to suck it up and deal with that craziness because I made the mistake of, you know, or whatever. Fill in the blank. It doesn't really matter. Divorce happened because divorce happened. Um, And so I wanted to share a few of the things that have helped me because I've had a lot of shitty stuff happen. But then on the other hand, I've also had some things happen to my benefit. And it wasn't just, they didn't just happen. You need to know the laws. I mean, each state has primarily they're going to be the same. A lot of the laws concerning child support, enforcement, uh, blah 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 are going to be the same. But then each state has one or two little things that maybe they do a little bit differently. In my case, Missouri. I've been dealing with Missouri for quite some time. The very first thing tip. So basically, this is going to be a video about tips. Some things that you can do if you're just getting divorced and now you're starting to weed through all the problems of child support. This is experience talking. I mean, I've made a lot of mistakes, but then on the other hand, I've also got some things that I can give you that you can look out for and protect yourself for however many years that you're going to be, in this situation of paying child support. And another thing, before I get too far into it, it is a father's rights page. But I also have a lot of friends who are the non-custodial parent that have just been absolutely stepped on by rules concerning how non-custodial parents are treated in the state that they live in. So this is not just a man's thing. In my case, it is. The child support enforcement is heavily swayed towards the custodial parent in the state of Missouri. More so when it's a woman. It's a fact. It's the way that it is. And so without getting too far off the beaten path of that, I wanted to bring up a few things, and I made a list because I get a little bit, I get a little sidetracked sometimes. But some of the things that stick out in my mind are some of the biggest mistakes that I made, and that maybe can help somebody that's getting ready to, or is in the middle of, or going through a process of, working out the child care plan, or whatever the case may be, anything that's concerning child support. But kind of the very first thing that I wrote down, because I was watching a video by one of the other guys on this, and he was, it was talking about visitation. And one of the things that you really need to understand is when you're served with divorce papers, it's a legal process. And what's on those divorce papers is not what's final. It's what the mother, or in my case, or the father, or whatever the situation may be, when it comes to the child care plan, it's what one of the people, usually the person that can afford an attorney, has put together as a potential care plan for the children. It's negotiable. It is not by any means, until it's signed into a civil order, it is not written in stone anywhere. Do not just sign your divorce paper, or the paperwork that you're served, because whether it be served through, some states will allow it through mail, but I don't think, very few. Most of the time, there's a service process that's involved, where somebody from the local sheriff's department or a public server comes and presents you with divorce paperwork. A lot of non-custodials, because they're ugly, or because of the situation is ugly, will just sign. They won't look at what they're saying. They're so mad about the whole process of support. They're mad because there's a divorce going on, and they're looking at the potential for financial loss. They're looking at the potential of not seeing their children as much, and they're just overwhelmed with the whole process, and they sign. And I encourage you, don't sign anything. Don't sign anything. And then as a side note to that, I got divorced as I was shipping out to Iraq. There's certain rights that service members have that no legal processes can be brought against you if you've been, federalized or brought onto orders. So at that time, I could have said, "All stop, halt the whole process, and we'll deal with this when I get back from going to war." I didn't do that. I grabbed up the papers. I was pissed off. I was overwhelmed with all the other stuff that was going on. I was sitting there thinking about the fact that, I'm leaving. I could not come back. And I had, and the last thing that's going to be the last memory that my children are going to have is me going off to war, not coming back, and a divorce. And it was overwhelming for me emotionally and mentally. So don't sign the papers. First thing. And I know I kind of digressed, but steps wise, don't sign the papers right off the bat. Read through them. Take them to, especially if you're military, legal assistance on base. Have them look through there. A lot of times, they shoot for the moon. And if you sign it, that basically says to the judge that's presiding over that civil order, hey, they agree with it, so I'm going to make it an order. Don't do that. It doesn't matter if you're getting deployed. It doesn't matter if you're whatever the case may be. Don't sign your papers right off the bat. Take a breath, take a knee, think about things for a little bit, breathe, do your breathing exercises. Go find some legal assistance. A lot of times it's free in a state, especially if you're low income, and have them look it over. Because if it's not 50-50, it's not fair. Because as a non-custodial parent, whether you're the father or you're the mother, you are just as important to the child's development as the other parent. So don't get it twisted and think that you're not. Okay? You need to have some time, think it over, look at the thing, read through it. If you don't understand it, take to a legal assistance office. There's no time. They can sit there and fuss at you about not signing it right off the bat, but know your rights. Secondly, another post that I saw in here that really struck home was about the fact that somebody was, talking about the fact that they had a separation order and all this other stuff. I'm almost positive now. That's like a playbook in law school for people that are going to be working in civil order, civil law. You're representing the custodial parent, and she goes in there, or he goes in there and says, this, and this person's a horrible person. That lawyer doesn't have any idea. You can't say the lawyer is the problem in this thing. Basically, anything that the lawyer puts on a divorce decree is what the person that's going to the lawyer says. All right? So a lot of times, if they make it sound worse than what it really is, then the lawyer's going to be like, hey, file an ex parte. It'll put in, even if you decide not to make it long term, at least for 6 months, they can't have any connection to you and all this other stuff, at least while we work through this process of divorce and da-da-da-da-da-da-da-da-da, right? All right. You got 6 months, at least in Missouri at the time that the ex parte was filed with me, I had 6 months. And what I didn't do is what I'm asking you to do. Understand that your kids are not to be used in this process. They're not to be used. They are not going to give witness testimony. You shouldn't ask them to. Not, especially if they're super young, they won't be able to be allowed to give testimony anyway. Even if they're older. That's a lot of responsibility and a lot of emotional baggage to put on a person's child, to ask them, hey, I want you to talk bad about the father, or I want you to talk bad about the mother. That's too much stress. That's too much emotional damage to do to your child. Don't do that. So you can't use kids, right? But you know what? People know you as a couple. You have friends. And some are going to immediately have the hands-off approach. It's not my business. You guys do your thing. Work through your stuff. I'm not going to get involved. But there's some that knows that the non-custodial parent or the person that's, there's sometimes it's very obvious. And if there's anybody willing to give character reference or anything like that, you need to bring that stuff with you to the ex parte hearing. The first thing, remain silent. I mean, at least in the courtroom that I went to in Camden County, Missouri, in 2006 or 2000, whatever it was, 2007 or 8 or something like that, when she filed an ex parte on me, the judge was loaded for bear. He had no intent. I mean, I walked in, I looked nice. At that time, I had just come back, or I'm sorry, it was right before I left or something. I don't remember. But I was in my uniform, and he didn't give me an option to talk. Right? I had my parents show up. My parents showed up, and they were sitting there. That was the only people that came to the hearing at that particular time. Was some people in the back, I guess, waiting for another hearing. My two parents who sat down and waited for me, my ex-wife, and me. And the judge asked her, do you feel like this needs to be a permanent order? And she just kind of tap danced around it and said, no. He said, excuse me, I'm going to give you another chance to answer this. Do you? No, I don't think so. Here's the reality, right? There's still feelings there. And most people, if they're half a human being, understand that interaction with your children is just as important for the father as it is for the mother. So don't let the whole ugliness of a divorce cloud your judgment on whether you file an ex parte or you go through the whole legal process. Because sometimes it's better just to give each other space and let the legal process of the going through the process of going through your divorce decree and making sure that all the I's are dotted and all the T's crossed is more important than calling the ex or having communication with the ex. Sometimes you need to have it, right? Like, let's say there's a 6 month period in between the time. There's a waiting period in some states where you file a divorce and then there's a waiting period, and you want to see your kids, right? Then send emails or send certified letters. I mean, I know it seems silly that, a person that you were able to just text before, but you're not dealing with that anymore. Now, once the divorce has started, it becomes a legal process. And how do you show a court that you wanted to spend time with your kids for the last 6 months, that the divorce was in, she was unwilling to do so? Certified letter. You have your address. Send a letter, put it in there. She signs for it, and you have a copy of it that basically you can show to the court. I sent a letter every week, and she would not let me for 6 months see my children. That's one of the reasons I want 50-50 custody. Very important that you don't just do things out of emotion and anger. You do things smart. You got to start thinking smart, or you will lose all your rights, and you will be lumped in with the rest of the U.S. as a non-custodial parent that's just getting browbeat by the civil court system. I went too far on that. Third, there's responsibilities of the custodial parent in a lot of states. Missouri is one of them, to provide, especially in secondary education situations. Mostly in secondary. It's one of the only ways that you can get a credit for child support. If the parent says that the child is going to school, secondary, college education, let's say that they're, 18 and they've started college already because they turned 18 in the high school senior year, and now they're already enrolled in college for the spring semester. All right. If they don't provide you proof of enrollment, and if they don't provide you proof of, what's the other word? Proof of, I don't know. Anyway, it's like the grades, basically. They're wrong. And you can file an affidavit, at least in some states, not every state. And this is not legal advice. This is just advice that I'm giving you as another non-custodial parent. If they're not doing that, they are not entitled, in Missouri anyway, to continue to get child support for that child. They have to provide you proof of enrollment and the fact that they're going to school, and that they're going to school and getting good grades. That information, if it's not provided, after, I think, the October after they graduate, in Missouri anyway, you are able to file an affidavit for credit of child support. In some cases, if they don't have any intentions of going, and a lot of times if you're talking with your kids, you'll know whether they want to be going to school or not, or secondary, go to college or not, then you can sometimes get them removed from the child support order. I got more information about that because I've done it with, with three of my kids, one of which, my oldest, was told, if you're not going to college, you're not going to live under this house. Now, it goes back to what I was talking about, not using your kids in this process to beat each other up. That changed the way that my daughter thought about her mother. For real. So don't be the non-custodial parent that sits there and anytime you have time together with your children that you're constantly talking about the other person, or you're running them down, or you're whatever the case may be. That person is living their life. You don't need to involve yourself in all that stuff. What you do need to involve yourself in is the life of your child, or children in my case. I made that mistake many times. I would be so frustrated with the things that she was doing to me financially, that she was doing to me through the court system, and that they would just take her word for things, that she was filing signed fraudulent claims, and they would just accept it, and then they would try to enforce it, and I had to go through the process of clearing my name over and over and over again. That's not your role, especially as the non-custodial. Show them a difference. Make every moment that you have with them something that you're making with them. Don't fill it with the garbage of your legal battle with their other parent that's on the order. So proof of enrollments is super important. And if you're not getting those, if they're not being provided to you by the student or the custodial parent, they're wrong. Then you can file an affidavit with the state to get credit, at least in Missouri. Check your own state's rules to find out if that works for you. So those are just some of the ideas that kind of popped into my mind. I mean, I've got a ton of them. I mean, I've been dealing, like I said, with this for close to 13 years. And I'm not saying that I'm winning the battles, all the battles. I mean, there's some that they've just straight, Missouri counts BAH, an allowance for housing that fluctuates depending on where your orders are against child support. Once it's become a civil order, there's like a 3-year, you can't make any changes. I got stuck where, they did a hearing for change of the child support amount modification. And I happened to be stationed at that time in the Bay Area. I mean, the Bay Area has one of the highest BAHs in the world. I mean, you actually get a cost of living allowance on top of the BAH because the cost of living is so expensive in the Bay Area of San Francisco. So that being said, there's a lot of things you got to dot your I's and cross your T. Any communication, it needs to be in writing. Do not make phone calls and gripe and complain at each other over the phone, because she's going to use it. She's going to say that she's being threatened. And you don't have any way to provide any. I blocked my ex-wife. I blocked my ex-wife, and then I started communications only through text messages and emails. Well, I found out later on, text messages a lot of times are in it. You can't put them into any sort of a legal proceeding. So I started doing emails. Now I don't do anything but certified online email. No, certified mail. Excuse me. They have to sign for it. It has a tracking number. It shows when it was made, when it was received. It's just a better way to go, especially when you're dealing with a combative co-parent. Questions? Let me know, man. Or a woman, or whatever the case may be. I'm here to, help if I can. So good luck all. Have a good day. Keep your head right. And love your children.